Well, welcome everybody to this first City Planning Committee meeting for 2022. I hope everybody's had a good break and raring to go with the planning matters and items that we consider tonight. I'd like to remind everybody, obviously we're at a distance and doing this remotely because of the COVID-19 legislative requirements to be apart from everybody. So this is being live streamed and recorded this evening. So in recognition of the deep history and culture of this place, I wish to acknowledge the traditional custodians of the land upon which the City of Hobart was built. I acknowledge the determination and resilience of the Palawa people of Tasmania, La Trawitta, who have survived invasion and dispossession and who continue to maintain and strengthen their identity, culture and rights. I recognise the value of continuing Aboriginal knowledge and cultural practice and pay my respect to elders past and present, and to those First Nations people who may be listening or with us today. So we have a full composite of committee tonight. So we have Alderman Briscoe, we have Councillor Harvey, Alderman Barakis, Councillor Dutta and Councillor Coates. Mr. Noy is not here, he's on leave at the minute, so we have acting in his place Ms. Aby, Karen Aby, and also as the planner who is here for any particular questions, we have Mr. Adam Smee. With that in mind, and if you have any questions, please let us know. We have nobody to co-opt. Can I have somebody move that we confirm the minutes, please? Thank you, Councillor Harvey. Is there any dissent? Now I see you too, Councillor Dutta. Is there any dissent? No dissent, so those minutes are carried. Item 3 is consideration of supplementary items, but I don't think we have any. Do we have any indications of pecuniary or conflicts of interest for any of the items here tonight? Nope. Transfer of agenda items. Any wish to transfer the items that we have before us? No. Okay. So item 6 is planning authority items, consideration of items with deputations, and we have three items tonight with deputations. Can I have somebody move that, please? Thanks, Alderman Briscoe. Is there any dissent? No dissent. I declare that carried. So item 7 is the committee acting as a planning authority, and we move to item 7.1.1, which is 114 Lord Street, Sandy Bay, partial demolition and alterations. We have a number of representatives, and we'll start with Mr. Ben Swain. And Mr. Bill Fitzgerald is speaking, but also represented by Ms. Danielle Gray. So I'll ask you, Mr. Fitzgerald, just to keep your comments to the specifics rather than what Danielle will be speaking about, if you wouldn't mind. But before we start, I'd just ask, because there's been a bit of to and fro with emails on particular points, I'd just like to, Ms. Aby, to just give us a little bit of a rundown of some of those things that I raised earlier.
Thank you, Chair. There are a couple of issues that have been raised both in the representations and subsequently. One of those issues is whether or not this application has been appropriately notified to the adjacent landowners, including Mr. Fitzgerald. Our response to that issue, when I say our, that's myself and the Manager Development Compliance. We compiled a memo and that was placed on the hub, so hopefully elected members have seen that item. So that addresses our views on that issue, and in summary, we form the view that it has been adequately or sufficiently notified so that the application is valid. There's also a question about some of that adjacent land being that where there's a right of way being potentially also not sufficiently notified to that owner. We've looked at that issue today and we're satisfied that the land, since it's not registered and with the Land Titles Office, that there's no further steps required in relation to that land. There's one minor typographical error which I'll mention, and that is that we've accidentally mentioned York Street instead of Lord Street, but hopefully the context of the report makes it apparent what the discussion's about. I think the rest of it will unfold during the deputations.
Many thanks for that, Ms. Aby. So we'll start with Mr. Swain. So you have 5 minutes to address the committee, and then we'll ask questions if we have any. Thanks, Mr. Swain.
Can you hear me okay?
Yes, thank you.
Excellent. Thanks very much. Essentially, this development doesn't comply with the planning scheme, and it doesn't comply with the planning scheme because it's far more development on the land than the land can justify or the land can hold. Given the limits of time, I'll deal specifically only with the issues, and I'm available for questions at any time. The sheer bulk of the development means that it will overshadow our property. In addition, it causes issues with setbacks, and its bulk doesn't fit within a residential heritage neighbourhood. Dealing particularly with 11.4.2 of the planning scheme, I note that it's said to rely upon performance criteria P3. And I remind everyone that the 2-bedroom apartment is built up to 1.3 metres from our boundary, and on the plans provided will overshadow our living areas, our dining room and our living room at the winter solstice. The report from Council's planner says that because the proposal will not reduce the daylight to our living areas below 3 hours per day, that is reasonable. With the greatest respect, that cannot possibly be the test. There are 9 hours of sunlight that we receive in Hobart in the winter solstice. The suggestion that if 6 hours was blocked, that's reasonable, that just makes no sense at all. Our house is set up, designed and built to get that morning sun. We all know how important the morning sun is in Hobart, and clearly this will result in about 2 to 3 hours of overshadowing into our living room in the winter, and that will result in an unreasonable loss of amenity, which is what the first criteria in P3 talks about. And really the suggestion that it somehow needs to block out our sun for 6 hours, that's frankly nonsense. There can simply be no justification for that position that Council's taken. That is in relation to our living areas. The second criteria, as you know, also relates to overshadowing of our private open space. The same points I've just made, which I won't labour because of time, apply. Of course, we have more private open space than we have living area, so the shadow is there for longer, but nonetheless, those issues still apply. The last one in P3 is the visual impacts caused by the apparent scale, bulk and proportions. Again, this building is over 1.5 metres higher than the existing building. It will also be in a rectangular block shape rather than the existing building that is more of a sort of shark dorsal fin shape. That will again create a greater bulk and again impacts upon the visual appeal. One thing I must point out again is yet another error in Council's report, where it says that this second story bedroom apartment, one bedroom apartment at the rear, will be partly obscured by existing boundary fences and or softened by vegetation. That's simply wrong. There is currently vegetation there, but it will be removed as part of this development. So Council seems to have come to this conclusion simply upon an erroneous understanding of the facts. And I might note that council's officers didn't attend at our property, and perhaps if they have done so, these errors that are here mightn't have been overlooked. The last point I would make about the rooftop terrace, that's going to cause an unreasonable loss of amenity to us as well. I'm not aware of any other property in the surrounding residential area that has a second-storey rooftop terrace constructed right up to the boundary. This belated addition of the screening wall won't stop someone of my height from being able to look over it, and creates more bulk in and of itself. So once a proper analysis of P3 is undertaken, 3 of the 4 criteria are not satisfied, and of course only one needs to be not satisfied for it to be in a position where it should be refused. And I would say it should be refused.
30 seconds, Chair.
Good, thanks, Mr. Swain. And I'll open it to the committee for questions. All right, just having a look to see who's raising. Can you just let me know who wants to ask questions? Sorry, my screen's just not showing me everybody there.
I'm happy to go.
Councillor Coates, thank you.
Look, thank you for that, and thank you for your written submission as well. It's obviously very thorough, and you've spoken to it well. I just wanted to know, one of the things, obviously, an element of this is they're seeking to use the performance criteria. I was just curious to know, in the design applicants come up with, did they in any way engage with you as a neighbour, seek to sort of say, look, we are proposing to do something here, but how can we design it in such a way that we're both sort of happy? Were you in any way sort of consulted, or felt like you had an opportunity to engage with them prior to seeing obviously this application?
No, councillor. The first time I saw the plans was when it had been advertised by council. The notice went up on the property and the plans went up on the website. I never saw the plans at any stage prior to that.
Okay, thank you.
Councillor Harvey.
Yes, Mr. Swain. What sort of conditions would you suggest that might make this more acceptable development?
I can suggest conditions to deal with the rooftop terrace issue. I can't think of any to solve the two-story apartment issue. So I'll go through the rooftop terrace ones if you'd like me to.
Yeah, I'd be interested to hear, yep.
So the rooftop terrace ones, and I might add, I went across to the applicants after the advertising of this and told them my view and suggested this to them as well. If the rooftop terrace was a garden and a garden only, that is, there was a condition in the permit or a Part 5 agreement or something like that, which says that it wouldn't be used up there as a rooftop terrace for people having beers or looking down on it or socialising and whatever. This was garden only, so it could be used for the purpose of planting the garden, maintaining the garden, watering the garden. That would be fine from my point of view. That would also mean that the 1.7 metre screen wouldn't be needed, and that would take away the bulk that the screen causes, and that would also remove the likelihood that people will be standing up on the rooftop terrace and overlooking our property, using it as a rooftop terrace. So they would be my suggestions in relation to the rooftop terrace. I can't think of any in relation to the two-storey unit at the back, other than, and it would be quite flippant to say it, but reduce the height of it and move it backwards. But you can't put a condition to that effect, whereas my suggestions about the rooftop terrace can be done by conditions.
All right, thank you.
Further questions? If not, I'll thank you for your deputation, Mr. Swain, and I'll now call on Mr. Fitzgerald.
Sorry, could I just make one brief comment about the comment that was said at the start of this meeting by the council representative, please?
Well, no, actually, you've had your 5 minutes, so I'm going to hear from Mr. Fitzgerald now. So thank you.
Thank you.
So if you'd like to turn off your microphone, thank you. Mr. Fitzgerald, do you want to put your microphone off mute, please?
Thank you. Yes, I am aware of the representations made by Mr. Swain, and I've had some discussions with him, and I believe that our situation is pretty much the same as Mr. Swain's in reverse. I've certainly endorsed his representation, and also the representation made by Reese and Anne Williams from 18 Lord Street. I know they're not appearing on this today. The other one was the supporting representation. I find these processes a bit bewildering. I normally work in the Fair Work area, and I would have thought we would have some detail of the supporting representation so we could respond to it. But that's not possible. But all I say about that is that it is a particular view by a representor, and who says that just because the same firm of architects is to be used by the developers as they did with their principal residence, then it's going to be architecturally pleasing. I think that's just an absolute nonsense. And I think that supporting representation, whatever it says, should be rejected. I think this whole development application is ill-conceived. And I think Councillor Harvey's questions about consultation and what Mr. Swain was about to say also about the Section 52 of the Land Use Act, it's clear that there has not been a proper consultation, and it's, in my view, the advice by Ms. Aby is incorrect, and it is a fatal flaw that the developer has signed a false declaration in respect to consulting with myself and my wife, both on the 13th of August and prior. That is simply not so. And I do intend, if the council doesn't take it up, I do intend to raise this matter with the DPP, because the Act provides a penalty for a false statement. So it's my view that this whole application is fundamentally flawed because of that aspect alone. The developer, in my view, has acted mischievously the whole way, particularly Ms. Lucy Harris. We've had a number of discussions over the years regarding our objection to this development back in 2000 for a second story by a former owner. And as a result, it's our view that Ms. Harris has just concealed this from us until the very last moment when we saw plans when it was first advertised. We've had nearly 40 years in our family home. Now, I'm partly retired, but as you can see, I volunteer for the Cancer Council, which I really enjoy doing, as well as Lifeline. We're enjoying our property, and we've invested a huge amount of money into our living space, recreational space, our pool area and garden space. And this development will simply overlook it and diminish our amenity. Specifically, the two-storey garden, and it was hard to work out from the plans what it really was, overlooks these spaces. It will impact on our amenity. It's not only our primary living space, but it's our recreational space, it's our garden space, it's our pool space, it's our outdoor bathroom space. The solid mass of a two-storey unit, which is now currently, we compromised back in 2000 with a skylight as it currently is. But the effect of this is that rather than having an opaque see-through skylight, it will now be a solid space, which will impact on our views to the mountain and the like. The other issue I'd like to raise, and it was raised by Mr. Swain in his representation, is that in my view, the developers. I'm sorry. I didn't hear anything. Sorry.
Sorry, Mr. Fitzgerald. It's 30 seconds to go. So if you'd like to summarise, thank you.
Right. Yeah. The other issue is that there will be 3 separate uses on this very small, tiny plot of land now. The residential use by the developers in there at 14A, a commercial use for their building and within the garage space, the lock-up garage space, and an Airbnb use with the new unit. And the final point I'd like to make is the developers have had this property, or had their own property on the market for some time. The nature of their business is that they will develop, gain the profits, leave and sell, and go and develop another project. And we think it's very inappropriate that we're left with holding the baby, but with an inappropriate blight on the landscape. Thank you, councillors, for listening to me.
Thank you. And I might start with a question. So are any of the conditions that you have seen in the report, do they satisfy any of your concerns about that?
They don't, no, Councillor Burnett, no.
All right. Any further questions for Mr. Fitzgerald? If there are no further questions, thank you very much, and perhaps we'll hear some more of your concerns through your representative, Mr. Fitzgerald. So if you'd like to turn your microphone off, and thank you. And
thank you very much, Councillor Burnett.
I'll call on Ms. Gray. Thank you. Sorry, Councillor Dutta, did you have your hand up to ask questions? Just take yourself off mute, please.
I'm sorry, I did, but I'm having some difficulty with this technology, trying to push it in and push it out. So that's why it's a bit late. And so I missed you.
Do you want to ask a question now, or can it wait for Ms. Gray?
Thank you. If I may be given that opportunity, I'll appreciate it. Thank you so much. Just wanted to ask Mr. Fitzgerald that having received a statutory declaration and the points that were made clear, the points clarified by Ms. Abbey, I was wondering if I could ask a further question later on, just to clarify that. Will that be possible, so that he doesn't feel I haven't addressed that issue?
Why don't you ask it now, Councillor Dutta?
Oh, okay. Now, the statement you're making here, that it is an incorrect advice, could you just clarify that a bit further to me, please? Why do you think it is an incorrect advice?
Yes, thank you, Councillor Dutta. The statement made under Section 52 of the Act declares that Lucy Harris, the developer, declares that she had discussions in detail, which in my view would require the production of plans and the like of the proposed development. My wife has also signed a statutory declaration refuting that, and said that there was a cursory discussion about the type of development only, nothing more. Further, Lucy Harris says that she had discussions with us from 4 to 6 months prior regarding this, but we had no discussion whatsoever. The discussions we had from Lucy Harris were varied from having a swimming pool in the area to open space to a rooftop garden, but there was nothing of any firm nature indicated by Ms. Harris. So we say that is a false declaration. That in accordance with the Act, the false declaration incurs a penalty, and if the council won't take it further, we will, because we believe that.
Thank you, Mr. Fitzgerald. I hope that satisfies your question, Councillor Dutta. Can we move on? Okay, right. So now over to you, Ms. Gray.
Thank you, Chair, for the time in allowing us to speak. I'm a planning consultant. I'm representing Bill and Wendy Fitzgerald, who live at number 12 Lord Street, directly adjacent to the development site, and they have a right of way over the shared access. I will touch very briefly on the issue of the validity of the application. And thank you for the additional information provided this afternoon with respect to Council's view as to the validity or otherwise under Section 52. The information I've been provided by my clients that conversations between Ms. Harris and Mrs. Fitzgerald, according to the email provided to Council, that, and I quote, it was a full and detailed description of the proposed development, including the use, nature of the demolition, new garage proposal, rooftop private open space, as well as a single bedroom double-storey dwelling. I've been repeatedly advised by my clients that the conversation, which occurred, I think it was 4 or 5 months before Ms. Harris would have been aware that 12 Lord Street was part of the development site, and therefore 4 or 5 months before she would have been aware that she had to make a declaration under Section 52(1) of the Act, that the description was, as I understand, development ideas that were non-specific and vague and ranged between providing more private open space or more parking or a new luxury Airbnb. There was no more detail provided than that. So as confirmed by Mr. Fitzgerald, they will pursue that once a decision is made tonight either way about the application. It's my view that a random conversation about ideas about a proposed development does not constitute notification as required by the Act, which actually requires that the applicant has notified the owner of the intention to make the application, not vague random development ideas. The second of 3 issues that I'd like to discuss is the use of the shared right of way. The access is longer than 30 metres, and under E6.7.3A1, a passing bay is required. No passing bay is provided, and there is no ability to do so. The access will be used by 3 different households to provide sole access to a total of 5 car parking spaces. It also provides sole pedestrian access to 14A and B. Ms. Harris has approached my clients and advised them that they have no ability or right to manoeuvre within 14A or B, so that they can manoeuvre their cars and leave the site in a forward direction. On that basis, the Fitzgeralds have no option but to either reverse up or reverse down the driveway when parking their vehicles. The P1 performance criteria, which has been assessed, and the wording is quite specific in my view. It states that vehicular passing areas must be provided in sufficient number, dimension and sighting, and then goes on to say that the access is safe, efficient and convenient. The criteria does not state that vehicle passing areas have to be it states that they must be provided. It does not state that they may be provided. It does not give the option to provide no passing areas. It simply states that vehicular passing areas must be provided in sufficient number, dimension and sighting. Regardless, it's my view that the absence of any passing area at all will result in conflict from vehicle users from 3 different households, one of which is required to reverse the entire length of the access lane. It doesn't meet the performance criteria that it must have regard to, and it certainly doesn't provide any vehicle passing areas, which it's stated in the P1 performance criteria must be provided. While the proposal has multiple discretions, including encroaching outside of the building envelope, the other pertinent issue that I'd like to make mention of is the private open space provided by this development. As a planner, it is completely inadequate. If you look at the private open space, 10 square metres, approximately 4 square metres of which is to provide adequate swing room for the doors. If you have a look at page 61, there is no outlook. Residents will look at a blank wall in 3 directions around 2 metres in height. That includes the privacy screening. If you have a look at shadow diagrams on page 61, the private open space will receive around half the square metre or less of direct sun between 9 a.m. and 3 p.m. in June. If you look at further on, it's page 50, 4 square metres of the 10 square metres is taken up by door swing. There is no ability to locate even a single chair in the remaining triangle-shaped 5 to 6 square metres in total area of space.
Ms. Gray, that's almost time. So would you like just to summarise, please? Okay.
It's my view from a planning perspective that there are 3 grounds that this can be refused on, specifically 11.4.3, P1B, 1 and 2, and C. as well as P2B with respect to the failure to provide any meaningful private open space. There is also, in my view, that the proposal is prohibited under clause E673P1 for providing no vehicular passing areas.
Good. Thank you very much for that. I'll go to Alderman Briscoe.
Thank you, Chair. Thank you, Danielle. Could you just go through those three grounds again? Because I was trying to take notes and I wasn't fast enough. So.
Okay. So for private open space, it's clause 11.4.3, P1, B, 1 and 2.
Yep.
And also C of that clause. And there's also clause 11.4.3, P2B.
Yep.
It relates to providing private open space that will serve occupants and will provide for operation and recreation, etc.
Yep.
And the other clause that, in my view, is prohibited under with respect to failing to provide any vehicular passing areas is E6.7.3 P1. Vehicle passing areas must be provided. It doesn't provide any.
Thank you for that. Appreciate it.
Thank you.
Any further questions? Councillor Harvey.
Danielle, could you just please explain how you see the parking at number 12? How do they use their parking? Do they use that right of way and park out the back, or is there another car park at the front on the right-hand side?
They basically park their vehicles off street. So there's a double carport to the rear of number 12, and they use that access. They were on occasion using area within 14 to manoeuvre so that they're not reversing up or down for safety reasons. I understand there's been conversations between the property owners where number 12 were advised not to use any land for manoeuvring. So that would result in them either reversing up so that they can leave in forward direction or vice versa.
So did the previous owners allow that space to be used? Is this a recent occurrence, or how long has this been the case? In
terms of the manoeuvring?
Yeah, being allowed to reverse onto that side.
I can't answer that question. I don't know the answer to that. I'm sorry.
Okay, thank you.
Further questions? Mr. Fitzgerald, you don't have an opportunity to ask any questions, but never mind. Ms. Gray, it's an existing use, is it not, with that driveway, and obviously limited because of the land. Is it not used properly now? Or, I mean, I just wonder how the number of car movements that would be generated from this kind of development would change that.
Well, essentially, it's back to the drawing board. I mean, you're demolishing it and requiring assessment under the interim scheme, something that's occurring now. It may not be able to occur under the current provisions. As far as I'm aware, I think, and perhaps the developer could correct me, that I understand there's at least one additional car parking space now being provided, and they're formalising a two-car garage as well as one parking space as shown on the site plan. But it's my view, it's a situation that shouldn't have been allowed to occur to start with. Three vehicles using three households, 5 cars using a long, narrow driveway with no ability, particularly for my clients, to manoeuvre at all.
Okay, thank you. All right, so if there are no further questions, we'll go now to the applicant and the planner, so Ms. Lucy Harris and Jackie Blowfield. So you have, if you'd like to answer some of the queries that have been raised, I don't know that we need to go down the section 52 path, and that because we have our own advice in relation to that, but can you just answer some of the specific planning matters associated with this application. Thank you.
Good afternoon, Deputy Lord Mayor, Aldermen and Councillors. My name is Lucy Harris. Together with my husband Ross, we own 14A and 14B Lord Street, Sandy Bay. In 2015, Ross and I purchased 14A Lord Street. At this time, the 100-year-old Federation House was run down, dark and cold, lacked storage, lacked functional car parking, and had a significant eyesore in its backyard, this being the 2-bedroom dwelling at 14B. This dwelling was the result of a decision to strata title the land made around 40 years ago. We can only imagine this decision came of the want for financial gain rather than that of any common sense, as the resulting strata left 2 lots of land with inadequate space for much, especially for future residential development of 14B, gardens for either property or car parking at either lot. Perhaps this made some sense back in 1980, but it certainly doesn't today. Ross and I also own an award-winning building and design company, 2H Proprietary Limited. In 2015, we teamed with 1+2 Architecture to design and construct an award-winning extension to 14A and renovate the existing home, keeping its heritage in the forefront. Our home is now beautiful, light, bright, warm, and incredibly comfortable to live in. The only thing that it lacks now is suitable car parking, storage, and a garden befitting of a home this size. Ross and I are the first people in 40 years to own both properties and consider this a once-in-a-lifetime opportunity to address both properties' shortcomings. Hence, we have again teamed with 1+2 Architecture and submitted a development application for a new garage with rooftop garden along with redevelopment of the existing rear 2-bedroom dwelling into a 1-bedroom, 2-storey dwelling of apartment style. This is a highly crafted architectural design undertaken with extensive consultation by the architects with City of Hobart Planning and Heritage Officers and Heritage Tasmania. The sitting of the small 2-storey dwelling has been considered with regards to 12 and 16 Lord Street to minimise the impact upon their access to natural daylight and distant landscape and city views. The apparent bulk of the proposed 2-storey dwelling has been minimised through the use of flat roofs and stepped massing. Fixed and openable glazing to the 2-storey dwelling has been designed with sufficient building setbacks or fixed screening devices to maintain privacy for our neighbours. A landscape terrace space located on the roof of the proposed garage and has been designed to extend and currently limited outdoor space for 14A. Large areas of non-trafficable planters will provide significant areas of greenery to soften the overall appearance and help differentiate the proposed dwelling at 14B from the existing house at 14A Lord Street. I thank you for your time today, and I'll leave our application with you to consider. Thank you.
Thanks, Alderman Bennett. I'll address some of the concerns that have been raised from representatives. Concerns being raised that the rooftop terrace will create overlooking and loss of privacy for neighbours. The proposal will comply with acceptable solutions for privacy, with the terrace located and designed to be set back over 8 metres from the eastern side boundary and having screening, which is reinforced through the proposed permit condition recommended for the western side. In addition, the terrace is provided with non-trafficable landscaped areas either side, which will further reduce the potential for overlooking. The area of the development, which exceeds the building envelope, is located near the rear boundary. The development has been sited on the lot where the new upper floor area will be located, maximising distance to the nearest neighbouring dwellings on either side. The location of the upper floor area in this regard was a deliberate mechanism to achieve separation from the neighbouring dwellings and to place the upper level where its impacts would be minimised. In relation to the concerns raised about the amenity of neighbouring properties, the matters of consideration of the planning scheme include shading and reductions in sunlight and visual impacts. In relation to loss of sunlight, the property adjacent to the rear boundary, 11 Duke Street, is northward of the site and therefore not affected. The shading diagram submitted as part of the application confirm the proposed development will not increase shading for 12 Lord Street and will only result in minor increase for habitable rooms between 9 and 10 a.m. midwinter for 16 Lord Street. This minimal impact complies with the performance criteria, as there will be no significant impact created, including that there will be no additional shading, which would mean neighbouring habitable room achieves less than 3 hours sun in midwinter. In relation to visual impacts, the scale and height of the upper floor area is modest. The development will be some 7 metres from the boundary with 12 Lord Street, where that neighbouring dwelling is in close proximity to the boundary, while on the 16 Lord Street side, where the dwelling is set back at a greater distance, the upper level is set back 2 metres from the boundary. The separation of the new upper level from that existing at 14A will reduce the visual bulk of the buildings on site by retaining visual separation between the two dwellings when viewed from outside the site. The rear elevation of the dwelling has been designed with the upper area stepping away from the boundary, which will reduce the visual impacts of the development by the separation of the upper floor from the ground floor boundary wall.
30 seconds, Chair.
The private open space.
Would you like to sum up, Ms. Blowfield, please?
Thank you. The private open space of the proposed dwelling, while less than the acceptable solution, is well designed and located where it will achieve solar access. If the committee is concerned about the size of the courtyard area, there would be the ability for permit conditions to be included to incorporate sliding doors as opposed to swinging doors. In relation to the parking areas, the proposal results in a reduction of the number of cars that will have to reverse up the driveway because the new garage area provides on-site turning for those two vehicles. Thank you.
Rightio, thank you. And Alderman Briscoe, you have a question?
Thank you, Chair. Yes, it's Blowfield. Can you just make a comment about the inhabitants of 12 Lord Street who believe that they will now have to back up all the time, and prior to this development, you used to be able to use summer 14 to manoeuvre?
I think, Alderman Briscoe, there's no formal right of way over 14 that benefits number 12. It sounds like there's been some informal arrangement in the past, and I don't think there's anything specific in this application that changes the current sort of legal status in relation to that matter.
Just as thank you for that. The supplementary question through you, Chair. So who actually owns the land the right-of-way is on?
The right-of-way is that title where there is no ownership over it. So certainly both properties have access over that right-of-way. I think previously number 16 used to use part of number 14's land to complete a turning manoeuvre. I think that's what's being talked of.
Right, and another supplementary, sorry about this, but to me, this parking issue is important, or the proposed new dwelling at the rear of your properties, would that increase the use of the right-of-way?
I don't believe so. At the end of the day, there's two dwellings that are currently on the site. There's one additional parking space, but the new dwelling actually has one less bedroom. So technically you might have less people living in the house than you could have currently.
Okay, thank you very much.
Any other questions? Alderman Brooks.
Thank you, Chair, and through you. Look, you did answer a few of the questions I was planning on asking already, and I've probably got a few for the planning staff. But just touching, I think what's the biggest issue, just from listening to the representations tonight, was the access and the driveway. Can you just speak to, or I suppose respond to the suggestion that the lack of adequate passing and whatnot, as suggested by Ms. Gray, effectively prohibits this? Because that's something that I'm trying to wrap my head around now, and just the adequacy of the right-of-way as it stands to service what's currently there in addition to what's being proposed.
Sure. So I guess there's two. Primarily, I take a different view from Ms. Gray. I read the provision as saying that passing bays are required to meet certain criteria, And so therefore, if no passing bay is required to meet that criteria, then that would meet the performance criteria. And I guess that's, consistent with the view of council's engineering, development engineers who have considered the parking and access arrangements and have determined that it's satisfactory and meets the requirements.
Any further questions? Okay, thank you both Ms. Blowfield and Ms. Harris. And if you can turn your microphone off, and I'll now open it to committee to ask any questions of Ms. Abey. Alderman Briscoe.
Thank you, Chair. The overshadowing issue, there seems to be some dispute about overshadowing, I presume the overshadowing of 16 Lord Street. Is it correct to say that you can only, it's reasonable to lose 6 hours of sunlight in a 9-hour day in midwinter, and it's still reasonable?
Certainly the assessment that's been done has been carried out within the framework which the tribunal has said is an appropriate framework. And I appreciate that not everybody is going to agree that that's what is reasonable sunlight in every circumstance, but that's the guidance we have from the tribunal, and we always try and make our recommendations in line with the tribunal's parameters to make sure that the decisions are being made consistently.
As a comment, I think it would be unreasonable losing 6 hours of sunlight in midwinter. But from your assessment, is that correct that they would lose 6 hours?
That's not my understanding. My understanding is that the main loss would be earlier in the morning, and that as the midday arises and into the afternoon, there would be still sunlight received by that property in the living spaces. Compared with now, for example? Yes. Well, I mean, there is obviously overshadowing now, and that the shadowing diagrams do differentiate between the current situation and how the development would influence the overshadowing. I can draw your attention to those, hopefully. Yes, look, sometimes the overshadowing diagrams are not clear, but if you indicate that there is some already existing overshadowing, and it wouldn't be a full 6 hours they would lose in comparison with what they have now. Anyway, I'm satisfied with the answer you've given at the moment. Thank you. The diagrams are at page 61. Yes, I'm aware of that. Yeah.
Thank you. Any further questions, or do we have a motion? Alderman Barakis, and then Councillor Harvey.
Thank you. I haven't got a motion. I've just got questions for the moment. Look, so just to clarify, I might be going into redundancy here in regards to the overshadowing, because I think that's one of the two major issues here. So long as they're providing at least 3 hours of sunlight during the winter solstice, even though different people might say that's reasonable or unreasonable, in the eyes of the tribunal, that would be compliant.
That's correct. Ms. Turner's on the call as well. She may be able to give further guidance about that issue.
Ms. Turner.
Sorry, if I could just have Alderman Barakis ask the question again.
It was just in regards to just getting some clarification on the shadowing, because there's a bit of, I suppose, some disagreements on the interpretations. Regardless of also putting aside what different individuals might say is reasonable as far as loss of sunlight, so long as they're still allowing at least 3 hours of sunlight to hit the habitable areas during the winter solstice, that would still be deemed to be compliant by the tribunal. Is that correct?
Well, ultimately, it will come down to an assessment of what constitutes unreasonableness, the tribunal in past decisions has determined that if you still receive at least 3 hours of sunlight per day, then any further loss above that is not unreasonable.
Yeah, thank you for that. I do have another question. And it was the same question I asked the applicant in regards to the right of way and the comments made by Ms. Gray, just as to the nature of the interpretation of the performance criteria regarding the access and move over lanes and such, so people can navigate the driveway. I suppose how did the officers interpret this within the context of what Ms. Gray was suggesting?
Yeah, certainly council has reached a different conclusion to that of Ms. Gray. Our position is that the performance criteria allows no parking bays to be provided that the other requirements of that performance criteria are satisfied.
Thank you for that, Chair. Look, I'll just provide. I'm still tossing up where I'm going to sit on this one. I think we need to put aside the issue of the notification or consultation with the neighbours. I know there seems to be some disagreements amongst the different parties here, and I think, correct me if I'm wrong, this seems like something that would be largely a legal matter, and not one for us to deliberate on. It's one for us we're assessing the application on its planning merits and not whether or not a certain party did things in a certain way or another. And if the applicants have done the wrong thing here, I imagine there'll be severe penalties, but that's not for us to consider. Is that correct?
Yeah, I think we've had the advice provided, but I'll seek advice again from Ms. Aby.
That's certainly the conclusion that we've reached, that once a declaration has been made and that forms part of the application, then we don't need to go behind what the substance of the notification was. We do actually always attempt to do that if there's a question raised about whether or not there has been notification, just to make sure that we're satisfied that the applicant says something's happened. But from our point of view, we say that the legislation requires there to be a fairly clear process for us to be able to understand whether or not there's a valid application. And here, where there has been that declaration, in our view, that's enough. And it would be a risk to the council if the application wasn't determined.
Yeah. Okay. Look, there are a couple of issues of this that I do have some concerns of. The main one being the driveway, but I do think that based on officers' advice, I am leaning towards supporting it, but I'm not quite locked in yet. I'm not quite 100% sure, so I'm more than happy to listen to debate on this. Just to confirm, the privacy issue on the rooftop terrace isn't a discretionary item here, is it?
Yes, there was a discretion. Let me just double check the planning report. Sorry, there's no separate privacy discretion. We've recommended a screen for the boundary between the development site and 16 Lord Street, and then the distance, as Ms. Blowfield mentioned, the distance between the other side of the terrace and the adjacent boundary is sufficient so that it doesn't trigger that privacy discretion.
Thank you for that. I'm happy to continue to listen to debate on this one, Chair.
Thank you. Councillor Harvey.
Yeah, I think Alderman Barak has covered the issues I was going to inquire about, but I'll stick with the rooftop garden though for a bit longer. Ms. Abbey, what's the deal with rooftop gardens with regard to use of that rooftop garden? So there's been a suggestion that a condition might be considered where the use is limited to gardening rather than partying or having a crowd of people on the rooftop terrace overlooking the neighbours. Is there any regulations around how it could be conditioned, or am I heading off in the wrong direction?
We would need to be careful that we are determining what the applicant has applied for. And in this case, they have applied for a space that can be used by people, and it's not just limited to gardening. And hence this, the screening provision and the carefully constructed garden beds, which aren't trafficable. So it's not intended that people would be right up against the boundary. There is intended that there will be another buffer within the terrace itself. So I would be reluctant to encourage you to condition that space isn't used. We could always add that as an advice clause, but I would have concerns about that as a condition.
Okay, thank you, Chair.
Further discussion, or is anybody willing to move it? Councillor Dutta.
Thank you, Chair. Just a question again. My concern is with regards to clause E673P1 with regards to manoeuvring and access, etc. And the elements stated was that it should be safe, sufficient, and convenient, I think, if I remember correctly. I haven't seen evidence presented in the report with regards to those matters. Can I have some clarification on that, please?
The application has been reviewed by the Senior Development Engineer, and he would have factored in the proposed use from both 14 and 12 Lord Street, about the way the vehicles would be moving on the site and how many vehicles would be using that access strip. And he formed the view that in the circumstances, it was appropriate to have no passing bays.
Thank you.
Alderman Briscoe.
Thank you, Chair. Look, I mean, overall, I think this is an overdevelopment of the site. We can understand that the applicant wants to have good design. I don't think any of us worry about, have concerns about the design. The impact of this development on the neighbours is significant. I don't think there's anyone moved a motion at the moment, right? Thank you. I'd like to move a motion on refusal. I don't know whether we've got conditions already worked out for a refusal. Can I just ask that question?
I haven't circulated any proposed grounds of refusal.
Thank you. So if we move the motion on refusal on 3 grounds, 11.4.3 Part 1 and 2, and Part 2B, 11.4 failure for public open space, and E67 Part 3 and Part 1 issues to do with parking and access. Now, I don't think we can condition a reduction in sunlight, but that is a concern of mine as well. There is certainly going to be a reduction of sunlight, winter sun, for the neighbouring dwelling. So I move that.
Thank you, Alderman Briscoe. Discussion on the motion before us. Councillor Harvey. Sorry, Alderman Brooks, have you got your hand up? Or?
I did just put it up. I think it was sitting with my hand up for quite a while, so I've just reset it. I do have.
Can you just do this instead? Thank you. But I'll start with Councillor Harvey.
Through you, Chair. Look, I'm sympathetic to the neighbours, but I'm also concerned that we may not have strong enough grounds, according to the report, to support a refusal in a tribunal. Could I just get some advice from our acting director?
Ms. Obi.
Through you, Chair. Given that the officers have recommended refusal on all 3 of the grounds that have been mentioned, I would have serious concerns about the strength of an appeal and indeed the costs of engaging both external planners and an external traffic engineer to in an appeal in those circumstances.
Chair, look, this is a really tough decision, like all of the decisions well, most of the decisions that come to us. I've got a lot of sympathy for the neighbours, but I'm also concerned that we don't have strong enough grounds to refuse this. So I think I will foreshadow an approval.
Thank you. Further discussion. Alderman Brooks.
Thank you, Chair. Look, I have listened to the debate, and if Councillor Harvey hadn't said what he said, I probably would have said something similar. I think I do appreciate the concerns, and received emails from and listened to the representations of neighbours, and I do appreciate their concerns, but we do have to, in our planning role, make as objective of an assessment as we can as to whether or not these applications fit within the planning scheme and are compliant within the planning scheme. And just speaking again, looking again to the issue of the road access, which I thought was probably the biggest potential issue. I'll just quote, the officers concluded that given the existing driveway configuration, blah, 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 considering that the existing 2-bedroom dwelling at 14B is to replace with a 1-bedroom dwelling, parking and access will likely be improved as a result of the proposal. I do think that it's difficult for council, should we vote to refuse this application, defend in the tribunal the argument that we're refusing this on the basis of access, when this is going to have less of a impact than what's currently there. The other issues, and once again, I appreciate that some people might not agree that 3 hours of sunlight in a day is an appropriate amount of sunlight, but if that's what the tribunal is holding as their standard or the benchmark there, then if we found otherwise, we can kind of expect what the result's going to be if this ends up in the appeals tribunal, where it likely will end up. So I think we do have to look at what the grounds are. We do have to take a pretty objective look at all of this, and we need to look at what is the decision that's most in line with the planning scheme. And I think the officers have a right in this regard. So I'll be supporting the foreshadowed motion.
Thank you. Either Councillor Dutta or Councillor Coates, do you have anything to say? Councillor Coates.
Look, a very interesting discussion, and very full submissions we've received from all parties. Look, in listening to the discussion, I don't know that the traffic one is perhaps a grounds that we could defend it on, and this might be a question for the mover of the motion. But I do think that there is a valid point that's been raised in regards to the overdevelopment of a site and the visual bulk and amenity. So look, I don't know that necessarily we should be directing a refusal on the grounds of the traffic. I think it's fair to say that that's been, perhaps it is a ground of refusal, and we heard from Natalie Gray, but we've had our officers look at it. But I think on the other one, it is more subjective, so to speak. And I do think there is a concern over the overall scale and bulk of what's being proposed. So that might be a question for Alderman Briscoe as the mover of the motion, if it'd be okay to remove the reason for refusal on the grounds of the traffic.
Alderman Briscoe.
Thanks for that, through the chair. Look, it's a genuine concern that's been brought by a representative. He gave us evidence today. Fairly qualified.
We can't hear you, Alderman Briscoe. You've done something.
Can you hear me now?
No, you're soft.
It's still very soft.
I'll move closer. Can you hear me now?
Yep.
Okay. I'm trying to have a very quiet year, but anyway, if I have to shout, I will. Look, I think we've got some good evidence from the neighbour that it is an issue. There is a planner engaged by the neighbour who agrees with the neighbour with the planning matter that this is an issue. So I'm not prepared to take it out. I'm sorry. Maybe if Councillor Coates wants to move an amendment to remove it, that's up to him.
Councillor Dutta.
Thank you, Chair. Now, in this particular discussion, having heard all sides of the argument and the different facts and evidence, I am inclined to go along with the motion and support it on the basis of E673P1. I think that for me is a reason that I would be able to support it and say, yes, I see objectivity and facts and evidence to vote for this particular motion. Thank you.
Thank you. I'll make some points. Look, I think we've had some twists and turns with this application. Obviously, the Section 52 has caused some alarm as to whether there was the appropriate discussion. There was not the necessity to have consent as such from our officers' advice, but be that as it may, the application before us, I think really the motion that we have before us, I cannot support, whilst I think that there are some flaws with the application. I think they are addressed with a number of conditions, and I know that that's going to be difficult, and difficult for neighbours, but I think that there has been a significant amount of conditioning, and I would suggest that we'd even add that condition in relation to sliding doors as well, should Alderman Briscoe's motion fail. So I'll put Alderman Briscoe's motion as it reads, which is a motion for refusal based on those 3 points. And I'll ask people to raise their hands for support of the motion. Those in favour? Those against? So it's a tied vote. Councillor Harvey, I'll ask you to move your alternative motion. You're on mute.
Yeah, I'll move the motion for approval with the extra condition with for the sliding doors.
Thank you. Do we need further discussion? All right. If there's no further discussion, I'll put that motion. Can you raise your hand if you're in support of that? And those against? So, Councillor Coates, you're against that motion? Right, so it's a tied vote. We go to full, this will have to go to full council now. And be decided with no position from this committee, which is always not the best arrangement, but that will go to full council next Monday. So thank you to those who have attended, and I'll go now to item 7.1.2 and ask Mr. Garth to ask the representatives and applicant's representative into the waiting room. Thank you. And we have Mr. Anthony Ellis with Claire Ellis. Can I have you address the committee? And you have 5 minutes to address your concerns, Mr. Ellis and Claire. Thank you. Just turn your microphone on, please.
Thank you. Can you hear me okay? Thank you very much. This deputation is on behalf of all the neighbours who have submitted, and I'm summarising the major matters impacting all of us. Subsequent deputations will address other specific aspects affecting one property more than another. And in fact, there's a wider set of neighbours that are also impacted by this property and the changes who've also spoken to us. We'll align our comments to this specific application for an extension of Unit 1, 816 Sandy Bay Road. But this application needs to be understood in context as the application amplifies the existing proven issues already occurring on the property around change of use. And hence, we're providing context in this deputation to allow the councillors to consider performance criteria for assessment properly. Shane Farmer owns both properties at Unit 1 and Unit 2 816 Sandy Bay Road. Unit 2, which is not the unit under consideration here, but has the shared driveway, actually, what's happened to my place, has become a full-time Airbnb property with no live-in host, using words from their own advertising as a resort-style self-contained property aimed at group gatherings, celebrate birthdays, weddings, or multiple families with children to enjoy the pool and resort-style living. The pool's now kept at 30 degrees Celsius all year round, high occupancy, and has a spa on a higher floor above the pool, increasing yelling and screaming across outdoor floors. Development of a party house has had a major detrimental impact on the residential amenity of the area, with 24 hours of uncontrolled use. No adequate visitor management and major neighbourhood issues, and multiple infringements of noise and light. The most recent incident was on Thursday night, the 21st of January, which was actually Friday the 22nd, because it was 1:15 in the morning. Neighbours were woken by a party. Two police officers attended and closed down, in their words of the police report, rowdy behaviour at the party. The application in front of you is to increase the amount of bedrooms and outdoor living area for visitor accommodation in the same location, the same owner letting it the same way, and will increase the further intensity of current use issues in a low density residential zone, altering the number of visitors, people, driveway, traffic issues, and needs to be seen in context around the proposed use and rejected in our view. The performance criteria listed in your PDF on page 150, listed as low density residential zone, and looking at 6.7.2, we don't believe it passes the performance criteria listed on page 151 around items B, C and D. Unit 1, 816, which is this application, already has a partial change to visitor accommodation approved by the council, plan 21203, referred to on page 145. And you note there's been no visitor management plan yet submitted. It's the same owner and the same manager as Unit 2, 816. And as neighbours, we already know that what's promised doesn't actually eventuate. And so we are asking council to ensure that the visitor management plan has explicit requirements, not just general broad statements. The performance criteria assessment around traffic, we believe needs to be reconsidered. Our written submissions show that we've sent in advance, show all neighbours have witnessed issues already and are concerned about people and road safety. The level of traffic and speed plus bike path issues on Sandy Bay Road mean the entry and exit to this property is quite tricky at times. All of us have witnessed many near misses, and the visitor aspect, as opposed to residential, with no familiarity with the road and a much higher vehicle use because we've converted it to visitor management, not residential. So for instance, with 4 bedrooms, we've seen 4 cars. Means the parking and the entry exit are highly problematic. As neighbours, we already know there's currently inadequate parking now without the extension that this application of an existing additional bedroom shows for actual use. And so visitors are often parking across the road in the Hobart City Council leased area of the Land Conservancy. TLC have spoken about the loss of parking to them already to us. And what this actually means is that there's much higher use of the street for a pedestrian crossing. People are having to run across the road to their cars on the other side. And many neighbours to the south of us have spoken about people crossing there. It's a very unsafe area and near misses.
30 seconds, Chair.
Thank you. Would you like to sum up now? Your time's almost up. Thank you.
Sure. So basically what we are stating is there's a change of use, increased intensity, and that hasn't been considered in the application. And so we're seeking for the council to look at that, both for Unit 1, Unit 2, and for the visitor management issues.
Thank you. And obviously this is something that we're looking at, or the council officers are looking at the moment. Are there, so you're saying that it's not a residential property presently?
Unit 2 is not, it's full-time, and this application of Unit 1 council currently has a visitor management permit on it. They just haven't done the visitor management plan, and it's currently sometimes in Airbnb, but sometimes it's not.
Thank you. Okay, we'll just open it to questions from the committee. So who would like to go first? Any questions? Councillor Harvey, then Alderman Briscoe.
So from your observations, how often are there different cars coming and going on this driveway onto the risky corner there?
Probably about every 3 days. Sometimes people come for a couple of nights only, 3 nights, not a lot more than that. So you've got a very high turnover, unfamiliarity with the road and traffic, quite dangerous.
So do you think the officer assessment has been based on the shared use of the driveway between Unit 1 and Unit 2, based on full-time occupancy by residents, or based on the properties being used for Airbnb?
It appears when we read it that it's based on residential use.
I think that's a question for the acting director, how we assess cars using a property if it's a property is being used for commercial purposes.
Okay, thank you. We'll ask those questions in a moment. Alderman Briscoe.
Thank you, Chair. I visited the neighbours at the weekend, as I think a few people did. The deck, are you aware that one of the conditions for approval was that the deck would be screened to a height of 1.7, and some of the issues to do with privacy might be overcome by that? What's your comments about that?
I think a subsequent deputation will address it, but there's both foundation issues from our point of view, but there's also an implication from your engineers that there is space for them to build screening and to use garden and landscape. But the evidence of what they've done to date with their already converted property is they don't do it. They rely on the neighbours doing it, and they will not use their own space for any of those requirements.
Yeah, thank you for that. Presumably a 1.7 screen on top of the deck, on the side of the deck, will have to be complied with because it's part of the building. But I understand your landscaping concerns. Thanks.
Further questions? If there are no further questions, thank you to the Ellises, and I'll ask now for Mr. Cedric Mannon to give your deputation, and if you can make different points from your neighbours, that would be useful. Thank you.
Thank you, Councillor Burnett, and a big thank you to the councillors that came to visit to give the application context. Can everyone hear me okay?
There is a very annoying ringing. Can everybody who's not speaking please turn off your microphones, please?
It could be Bill.
All right, so I draw your attention to the performance criteria, councillors. The landslide code, whilst it says is a low risk, the actual pictures that I provided of the back area, which is not on screen now, but further on in the application, it's probably the last picture. Yeah, shows that it's pretty much been fitted out for a landscaping type development. We don't believe that the foundations will support the proposed accommodation, and really would like some clarity around the retaining walls. Whilst the council classified the area as a low hazard in terms of landslide, what we've seen progressively on Sandy Bay Road is a shift in the water tables and also a shift in the land movement, whereby the proposed development is likely to slip into our yard if the retaining walls are not significantly taken care of. Can we go to the previous two pictures, please? This is the picture showing our fence line, which is our front yard, and the entrance to Shane Farmer's property. What Shane hasn't put in his application is that there's roughly about a 3 metre drop from his driveway down into our yard. There is precedence for cars coming up over that area and falling into our yard. And we actually had that incident almost 3 years ago, and believe that the current provisions around retaining walls require further clarification and investigation by council. And that sort of shows you the view from our property, 818 Sandy Bay Road, into Shane's property. In terms of the land movement, I've got Helen Gray, who owns the property immediately behind us, and we've seen quite a bit of water and land movement from Shane's property towards us, so that the retaining walls are a big issue for us. In relation to 6.9, which details the car spaces, the actual turning circle for the garage relies on the footprint of Unit 2816 in order to exit the property. This will cause further traffic issues in an area close to where our bedrooms and living areas are. And as previously indicated by the Ellises, we don't believe that this is adequate in terms of parking on the property. Also, there's a slight, I'm seeking clarification in the actual application. Section 4.1 is actually inconsistent with the recommendation in 7.3. It's very clear that Unit 1, 816 will be used as an Airbnb premises, and there's an application into council as such. Yet under the findings in section 7.3, which I'm pulling up now, it actually reads as the following. Apologies, I had it up on my screen.
What was it specifically relating to, Mr. Manning?
It says that it says, given that this application is not for visitor accommodation, these issues cannot be considered in relation to this application. So section 4.1 is inconsistent with 7.3.
30 seconds, Chair.
Okay, would you like to summarise, and we'll open it to questions.
I've also included a photo there, and whilst we understand it's within the footprint, it does significantly minimise light entering both our property and Helen Gray's immediately below us. It will block out our entire winter sun, and in fact the 1.7 metre privacy screen will further shade our property and cut out light from our deck. So whilst it will provide privacy, it may not shield us from all the noise of this proposed development being used as an Airbnb place.
All right, thank you. Now, any questions from committee? No questions, thank you. You must have been, Councillor Harvey, you have a question?
Sorry, Chair, for late entry there. Yeah, Cedric, could you just explain to me what it's like exiting your properties in that location? What's the traffic like most of the time or during the peak hour? Is it a precarious situation getting in and out of driveways on that corner, on that bend?
Yeah, we've seen many near misses coming out of Shane's property, and because of the people using it as an Airbnb, they're not familiar with the environment, including the bike paths that need to be navigated. We've seen many near misses, and as Claire said, the pedestrian traffic's increased. We're also getting beer bottles and a range of different other debris thrown from the Airbnb properties into our place. So it's become quite a nightmare for us in terms of the extra traffic, the additional noise, the noise and light pollution, and the physical pollution that's been thrown across the yard.
But just focusing on the traffic there. So the office, the council officer has said that they don't see it to be an issue, but as a local resident, you're concerned that there's excessive traffic due to the nature of the properties there.
Yeah, it's a precarious corner, and there's been a number of near misses that we've all observed.
Yeah. All right. Thank you. Thank you, Chair.
All right. Thank you. Thanks. And I'll now ask Ms. Marilyn Pennington-Smith if you'd like to speak. Thank you.
Yeah. As far as near misses, I've actually witnessed 2 accidents outside my gateway, which is 812, 814. So it is a really dangerous stretch, and my driveway is not half as challenging as Shane's, and several of my friends actually won't drive down it because getting out into Sandy Bay Road is just really something else. And if you're looking at peak hour time, well, it's practically bumper to bumper. And particularly if something happens on the southern outlet, you're lucky to get into the traffic. But, so my points were, with regards to the private and open spaces for the multiple dwellings, point 1.3, the multiple dwellings may be having private spaces, but we aren't. Our privacy is being impeded upon considerably. The front of my parallel to Shane's Airbnb, right down at the bottom one, you wouldn't be able to, well, I wouldn't like to develop that area anymore because it is just so noisy, loud, and the area where this development of the deck is looking at taking place, that's my garden area where I sit, and that's now got to the stage, even now, where it's really not a place you can sit quietly with your friends and have a glass of wine or a barbecue anymore. With regards to point 6.7, landscaping, I'd be amazed to see that. Since Shane's moved in, the whole place has really gone back. And I can imagine that he could say, I'm going to wait till all the development happens and then I'll landscape. But I noticed that one particular tree, which is included in his overall picture, he's personally told me that that's coming out anyway. So Shane with his gardening, I think would be interesting. I'm also interested in the stormwater. The inspection opening for the whole of that property's sewerage, which is obviously going to really cop it, is in my garden on my 814 block. And so I certainly hope it's up to commercial use because that's what's it's going to hit it. And when it is under pressure, it blows in my yard. I was also wondering about the driveway. I've actually lived in Shane's property. When I first came to Hobart, I had a small unit underneath the house. It was delightful, but the road was a nightmare, the driveway, and I personally fell flat on my back and really hurt myself with ice in winter, so that can be an issue. I was also wondering about foot traffic because there'll be obviously a lot of people can't fit into the car parking spaces and have to run across the road and then obviously walk down the road. Are there going to be rails? Because it is quite a steep decline. And also I was wondering about the grip that people could get. Is there going to be any place for pedestrians? So they're my main points.
All right, thank you very much, Marilyn. Are there any questions of Marilyn? I have a question. Just, I mean, it sounds to me like there's a lot of interference, but apart from that, I'm just wondering if I mean, you see, I mean, I think you've explained it pretty well, but you've seen deterioration in residential amenities since well, over the past little while.
Where are we looking at for? Do you mean in the garden and?
No, just generally, and the impact on your residential amenity.
Oh, yes, it certainly does impact. I'm fortunate in having a block between me and Shane or the development. But yeah, I've noticed like rubbish bins aren't taken in.
Noise.
And the noise level is just something else.
All right, thank you.
Would you like to finish, Cedric?
Yeah, sorry, Marilyn's just a little bit hard of hearing, Councillor Burnett. Marilyn reflected that she's been a resident for 40 years, and the last 2 years since Shane's moved in, we've seen a significant deterioration, both in terms of the neighbourhood being a place to reside, and also some of the unsavoury practices of some of the residents, which I've mentioned to various councillors that have visited. So we, as a collective neighbourhood, we've certainly seen a significant deterioration in both our quality of life.
Right. All right. Thank you, Mr. Mannon. Okay. Any further questions from council elected members? If not, thank you very much for all your presentations, and I'll now ask the applicant's representative, Mr. Monty East, to respond to some of those concerns. And I don't know if you've heard those concerns before, Mr. East, but they certainly have been raised by residents in particular around who've put in representations.
Yes, I have. I've read the document from council's officers. To me, at the moment, there's two issues. One is the application for the. Oh, lost you. Hold on, there we go. There's the application for the alterations to the top dwelling. And part of my, I just need to open a document here. Right. I've read and understood all the comments by the representatives. My brief for the proposed development did not include any change of use. It was just to revamp the building, take off an external staircase, form a new entrance into the building and put a double garage on. There already was a deck outside the existing house, and we've stepped down onto the garage for a new deck. If my client, and the brief was not that it wasn't a change of use, if my client wanted at some point to use the property differently, then he would probably need to make the relevant applications to council to get approvals to do that. And in fact, I think he's had some discussion with council even as late as today about that. The two issues, firstly, Design East has gone to some length to ensure that this proposal fitted within the scheme and the planning templates. Both the planner and council's traffic engineer have agreed through their assessment and RFIs and the usual process, which you know about, that the proposed development complies and can be approved. I believe the planner has adequately addressed the planning issues raised by the representatives. And the second issue, of course, is which all your representatives have referred to, is the use of the property, which is raised throughout the council's document. I would have thought if there was any issue with the way the property was being used, other than that approved, then that is a matter between the representatives and council's compliance division. Just to go back to a couple of things that were stated, the retaining walls and the like, and reference to the landslip area. The photo showed there the existing situation. Well, the existing situation of the timber framed, somewhat inadequate retaining wall would be taken away, and new retaining walls, new footings complying with the building code, and all that would comply with the requirements for safe construction. The other one was I think Mr. Mannon mentioned, was cars coming off the edge of the top of the driveway. We've gone to a lot of trouble to actually redo the whole of the top of the driveway, because when I first went to look at it, it was a disaster. And we saw very quickly a way of making that a more level area as you come off the Sandy Bay Road, so cars can quite adequately stop and be stationary, see what's happening, and then depart. The other issue Mr. Mannon mentioned was part of the planning permit requires necessary railing to go along that point, which is something that would be done as part of the building application. This proposal is for the internal alterations. A new garage would deck comply under the scheme and is separate from many of the representations raised. A lot of representations I can't really speak to because the use of the property to me is residential.
30 seconds, Chair.
Pardon?
Mr. East, do you have just 30 seconds to just wrap up?
Yep,
If you wouldn't mind, we'll ask questions.
I can do that. Yes, I understand what your representatives are saying. However, this is a residence, and as far as I can see, it complies with the planning scheme and the officer's recommendations. Thank you.
Thank you. Alderman Briscoe, you'd like to start?
Can you hear me, Chair?
Yes, thank you.
Thank you, Chair. Through you, Chair, to Mr. East. I noticed the conditions approval for that have been recommended by the officers doesn't include landscaping condition, I don't believe. Would you or your client have any problem with having a landscaping condition to the satisfaction of the director, and probably an advice for the other property as well? Only advice, because obviously this is applications for the property under question. A similar advice that landscaping be done on that property as advice, but the first one is a condition landscaping plan to the satisfaction of the director.
To what extent, Alderman Briscoe, were you talking about just adjacent to this particular unit or over the whole site?
Well, as you well know, we can only have a condition over the application side, but I was saying that we'd have two parts. One would be a condition if you had no problems with it, and the second one would be advice. In other words, please do some more landscaping for the other. It is a much overlooked site, and you're probably aware that a big deck, which personally I haven't got any objection to the big deck and the car parking, the double car park underneath, to me doesn't raise concern. It's just that screening that from the neighbours, so the neighbours' privacy and noise, etc., are not interfered with. So the question is a landscaping condition to the in other words, a landscaping plan be submitted to the director of planning that would have to be approved by him.
Yes,
condition.
I have no problem with that. There's about a 1.5 metre to 2 metre strip of land between the actual buildings and the boundary, and quite adequate to provide decent landscaping along that edge.
Thank you.
Thank you. Further questions? Councillor Data.
Thank you, Chair. If I can just follow up with that particular question that was asked. Now, it's my understanding that clause D43P1 states that the dwelling must have, and criteria B, reasonable space for the planting of gardens and landscaping. Now, I'm just wanting to once again emphasize that I haven't read anything of that in there, unless I missed it.
Is that a question to Mr. East or to Ms.
Yeah, to Mr. East.
Right.
In the permit, in the proposed permit?
Yes, yes.
Well, I haven't found anything in regard to that. No.
Okay, thank you.
Mr. East, obviously there's quite a lot of concerns in relation to residential amenity, as I've said, and I was just wondering what sort of expectation do you have, or does your client have, to meet some of those concerns?
Well, I think that there's probably been so many issues raised with him. Look, I can't really speak for Shane. He has a he does operate this Airbnb, if you'd like to call it that, a deplorable idea, on the lower dwelling, and there's been other alterations within the site. He now owns both the buildings on the site, and I'd imagine what he maybe in his eyes, he's trying to create some little empire for himself there. But I think what he does there has to be within what the community expect. Now, if he's not going to do that, well, you know, the council does have a compliance division which can make him comply with some of those things. I don't know how far you can go with things like that, but no, he hasn't really said what his full intentions are, although I would imagine that if there's enough criticism of his use of the site, he would probably modify his behaviour.
All right, thanks. And this is needs to be decided by the 22nd of February. So if the committee were of a mind to defer the decision, what would your advice be in relation to acceptance of deferral?
Oh, well, I'm happy to defer anything if it means that we can have an outcome that is good for everyone, not good for everyone else but my client. I wouldn't accept that.
All right, thank you. All right, are there any further questions, Alderman Briscoe?
Oh no, it's a comment when appropriate.
So I'll now open it to discussion, and Alderman Briscoe.
Thank you. Can you hear me, Chair?
Yes, I can, but Mr. East, could you turn off your microphone now, please?
Yeah, look, I think there's some compliance issues that really is not at the moment the concern of this committee, but I think they should be addressed. And I think the compliance people of the Hobart City Council are onto it. I would support a deferral to see whether there can be some understanding or agreement with the applicant, and there is time. So the fears of the neighbours I share, that it could become a mini resort in the middle of a nice, very nice residential area, and that is not the. I'm sure that's not the aim of the scheme. It is a residential area. Fair enough. There could be short stay accommodation in parts of it, but the whole place being a mini hotel or mini resort, I'm sure is not the intention of the planning scheme. So if we could defer it so the council can have discussions with the applicant and his representatives and see some of these compliance issues dealt with. It appears that there may be some breaches of the conditions of the lower residents, But look, that's not for me to decide. It's our compliance people. At the appropriate time, I'm happy to move for a deferral. Thank you.
Was there anybody in the interests of brevity? Is there anybody who particularly wants to speak to this or would be happy for a deferral? Councillor Dutty, you want to speak?
No, that's okay. I just wanted one question to be answered, that's all, because in regards to deferral, has there been any consultation or discussion with the applicant and the neighbours?
Ms. Abbey?
Through you, Chair, I'm not aware of any discussions directly between the applicant and the representatives. There may well have been, but I'm not aware of any.
Anything else, Councillor Dutta?
Thank you. That's it. Thank you so much.
Okay. All right. Well, we have a motion for deferral based on more advice. Alderman Briscoe?
Yeah, the deferral is for the council to organise discussions with the applicant and the residents and the compliance issues, to deal with the compliance issues and report back to us at the next meeting, presumably.
Thank you. So I'll put that motion for deferral. Is there any dissent? There's no dissent, so that's now deferred until it comes back to us. Thank you. Committee, are you happy to continue on? We have another application to consider, so a deputation. So thank you. So we'll go to 7.1.4, which is 1 to 7 Cedar Court, Sandy Bay, partial demolition and alterations, and we have the applicant, Mr. Ben Turner from Preston Lane, to address some of their concerns. Thank you. And thanks for those who attended for item 7.1.2 on Sandy Bay Road. And just getting Mr. Turner to connect to audio, and then we can hear from you. Could everybody turn off their microphones for those who aren't talking? Thank you. This might help with some of the audio. Okay, so Mr. Turner, would you address the committee of your concerns? Thank you. You have 5 minutes maximum. You just need to take yourself off mute.
Thank you for allowing me to speak. There's two conditions that have been, well, a number of conditions have been put on the proposed planning application. One of them is heritage number 16, which I've had discussions with the heritage officer and also the planning officer today, and I believe an amicable outcome has been reached. So the wording of that condition is going to be changed slightly to basically read that instead of a 1.5 metre height restriction, it'll be changed to a height approved by council, no more than 1.8 metres in height. So I don't know if that's been portrayed to the committee as yet, but if that is the case, our client is content to accept that, or happy to accept that condition based on those minor alterations. The other condition that has been placed on the permit, which we would like to question, is engineering 4, which is on page 253, which states that all driveways and so forth need to be constructed in to a sealed standard. The original application that we made to council had a section of grass pavers, which was directly under an existing established tree, which our client wanted to retain. And although, working with council, the council was fairly adamant that they wanted a sealed surface or impervious surface. So our client agreed to alter that driveway to a sealed surface, and in turn, it was agreed that that would impact the tree, and the tree would probably no longer survive. So it's documented now to be removed. Tasmanian Heritage Council have put a condition on their notice of heritage decision stating that that tree needs to be retained. So we've got a bit of a conflict here with the conditions. Hobart City Council stating that it needs to be a sealed surface, which will eliminate water being able to penetrate the ground, and hence the tree will most likely need to be removed. And then the condition from Tasmanian Heritage requesting that the tree is retained. So I'm hoping that the wording of Engineering 4 can be altered to potentially have an ongoing discussion with Hobart City Council to come up with an amicable agreement for that section of driveway.
Good, thanks, Mr. Turner. Is there any questions in relation to those, or is that fairly straightforward for the committee members?
I've got questions for the officers, not so much for the applicant.
Yeah, thank you. Okay. Councillor Harvey?
Just quickly, how big is the area that you're proposing to have grass pavers?
I think we might have lost.
We have lost him.
Mr. Turner. Okay, well, are we likely to get him back? Or is it relatively, sorry?
You'll need to join the meeting again.
Right, okay, well, is it relatively straightforward?
While we're waiting, can we ask that question in regards to the engineering?
Sure.
To whomever the appropriate officer is through the chair. I guess I'll just echo the concern raised. If we've got heritage advice that we can't get rid of a tree, ultimately, what's the path forward? Because I don't think the path forward is that, what does the applicant do? So that's one question. And second one is, what ultimately, it says here reason for condition, to prevent dust, mud and sediment, but is there a way to make it not a hard surface, but have it a relatively stable surface, if that makes sense?
Ms. Abbey?
Through you, Chair, I anticipate there's some room for movement, acknowledging that we are obliged as planning authority to impose the conditions which we've been notified from the THC. So there's no dispute that our conditions need to be consistent with theirs. I haven't been notified of this conflict until now. So perhaps the ENG4 can be reworded to something like comma or an alternate approved surface approved by the council, something along those lines, so that we can resolve this through the detailed design phase.
Yeah.
Thank you. Councillor Hubbard, do you want to ask you a question? Mr. Turner's back.
Oh, yeah, just, sorry, Mr. Turner, where are you? Oh, there.
Sorry about that. No, just,
no, welcome back.
Issues. Sorry about that.
Yep. I'm just wondering, how big's the area of impervious surface that you'd like to install underneath that tree?
It'll probably be around 25 to 30 metres squared, I'd suggest.
That's not significant.
No, but it is the final 8.5 metres of the driveway. So where the cars would be doing all their turning, definitely the plan was to have full concrete surface, so full impervious. Therefore, any tracking of the tyres is done on that hard surface, and then the straight line movement, or predominantly straight line movement, is with we had anticipated maybe grass pavers. So just that section in green. In the grass pavers, so it's a vehicular sort of suitable. There's a image of a car parked on a similar product that's just googled online, but a product that allows the water to go through, give the tree the best chance of survival, and still predominantly eliminates any dirt or gravel entering council's roadway. And as I said, all the tracking and movement would be done on the concrete surface.
Yeah. Okay. And that green area is an internal area of the property. It's not on the edge where you meet the road.
That's correct. Yeah, all internalised, or all housed on our client's property.
Yeah. Okay. All right. Thank you.
Okay, so if there are no further questions, I'll thank Mr. Turner, and we'll open the item to move. Alderman Brooks.
Thank you, Jen. Just a question to Ms. Avey. Just to make this as easy as possible and to avoid, micromanagement by committee, would a appropriate amendment to the condition be that the surfacing is as per the satisfaction or the approval of the director, and then let it get hashed out that way?
I'd be well, I think that the key thing, and having heard Mr. Turner explain further, I'm not concerned, but the key thing is that the turning areas are with a sealed surface, because that's where the most damage is done to the driving area. So
but if we left that to the satisfaction of the director, that could...
Yeah, I think that would be satisfactory. I think everybody understands what's being conceptually approved.
Thank you for that. That answers my question. Chair, I'm happy to move the recommendation with the change that the engineering for condition is that the driveways and parking areas be constructed to this, with surfacing to the satisfaction of the director.
Thank you. And the other condition?
And the other condition about the, apologies, let me pull it up, about the
heritage.
Fence, yeah.
Yep, thank you. Okay, any discussion? Alderman Briscoe?
Yes, look, I know this property reasonably well, and congratulate the owner for continuing to make sure it's up to date and whatever. I do believe it was a residence for a while of a former Lord Mayor of Hobart, which I served under. I won't mention his name, but it is a beautiful property, and it's good that these upgrades are happening, that it gets everyone's approval. Thank you.
Thank you.
If there's, Mr. Turner, just turn your microphone off. Thanks. But if there's no further discussion, I'll ask, is there any dissent to that amended motion? No dissent, so that's carried unanimously. Now, committee, we do have two other items to consider, but I ask for an adjournment for 10 minutes if we can. For 5 minutes? Okay, so we'll be back here at just after 7 o'clock. Thank you.
Thank you.
I'm back, Deputy.
Right, I think everybody's back in position. Who have we got? We've got Alderman Briscoe there as well. Yep, great. Okay, so we'll go now to 7.1.3, which is 62 to 66 Clare Street, and I think we have Mr. Fisher here to answer any questions that you might have. So I'll open the item for discussion. Any discussion? Councillor Harvey.
Yeah, Chair, I went and had a look at the site yesterday. I think it's a much improved proposition, these new change rooms, from what's currently there. So I'm supportive of the recommendation, and I'm happy to move it for approval.
Thank you. Any further comments? Mr. Fisher, there were some concerns raised by a number of representatives just in relation to impacts and just the visual aspect of the toilets in particular. Could you just describe how some of those things might have been mitigated, please, or somebody else from council who might have some ideas about that?
Yes, Chair, I think I'm the only person here to answer those questions. Thank you. Look, there were some representations from neighbours in the rear of the building, the rear of the existing change rooms and toilets. Raised a number of issues about visual amenity, the loss of a number of trees which had been planted to obscure the facility in days gone past, and some issues about which I think were more relating to the use of the oval rather than the actual facility that we're now upgrading. I think if you refer to the plans, in terms of visual amenity, the site has been, a number of pedosphrums are being removed, and we're looking to plant a number, I think 10 native trees at the rear of the building to break up the form of the revamped or redesigned change rooms and toilets. The size of the facility is single story still. It sort of conforms with the sort of I dare say the 1980s style of the original building, but it really represents a sporting precinct facility with much enhanced, greatly enhanced facilities for the users of that Clare Street Oval. Duplication of change rooms, obviously much better access for disabled and visitors in the public toilet area, provision of a kiosk and the referees room. The rear of the building, which is the complaint I think people had about from the houses behind, it actually sits below the street, and I think Councillor Harvey would have made that point, is that it actually sits, it's a sloping site and it sits below the street, so the houses do look over the top of it. I think that the design actually enhances the look of the original 1980s building. I think the vegetation work that we'll do, the replanting of trees, will further break up the block form of the building. We're trying to keep it consistent with its original form, but to make it more interesting, obviously. And I think, I suppose my concern is that it actually represents a massive improvement in the facilities provided to the users and obviously the sporting recreational users of the City of Hobart for such a well-used sporting oval. I think that sort of, I think in the report demonstrates that it represents a significant enhancement. It's funded by a sporting grant, and I think the work is it's part of our ongoing program to improve facilities across the city for sports teams and things.
Thanks, Mr. Fisher. Any further questions? Now, have you moved it, Councillor Harvey?
Yes.
So I'll put that motion. Is there any dissent in relation to this? Where's all? Oh, yep. So no dissent. I'll declare that carried. Thank you, Mr. Fisher. And you can probably help us out with this next one, 7.1.5, which is 30 McRoby's Road, the outbuilding storage shed. Any questions in relation to this, Councillor Harvey?
I'm happy to move this item as well, Chair. And I'm really pleased to see some movement up at the tip shop. It's been quite a while now, and I'd like to think that we can get them back to their full operations as soon as possible. So this shed will go a long way towards restoring some of the functionality up at the tip shop. So, you know, I'm glad to see this come to council, and I can't see any issues with it. It's replacing an older, I think probably maybe even smaller shed that was burnt down a number of years or several years ago now. With an arson attack. So I'm very sympathetic to what's been happening at the tip shop over the last couple of years with the lack of facilities that they've had. So I'm very pleased to see some movement here, and hopefully this shed can be erected ASAP.
Thank you. Any further comment? If not, I'll put the motion. Is there any dissent? No dissent. Motion's carried unanimously. We can now go to reports. 8.1 is the monthly building statistics. Can I have somebody move that? Councillor, sorry, who was that?
So moved.
So moved, right. Thank you, Councillor Harvey. Any dissent or comment? No, I'll declare that carried. 8.2 is the building statistics. Alderman Briscoe, thank you. You're happy to move that. So any comments or dissent? I'll declare that carried. Item 8.3 is the delegated decision report. Can I have Councillor Dutta? Thank you. I see that you've moved that. Is there any dissent? No dissent. Thank you. That's carried. 8.4 is the advertising report. Ms. Abey, is there anything of note, or am I asking Mr. Smee about that?
There's one significant application on Sandy Bay Road. It's a $5 million proposal for 7 multiple dwellings. There are some works on council land, so we know that it will be coming to the road reserve, so it will be coming to committee, that one.
Thank you. Alderman Barakis, are you moving that?
Happy to move that.
Thank you. No further questions. I'll ask if there's any dissent in relation to that. No, thank you. I declare that carried. Questions without notice. Are there any questions without notice? Councillor Harvey, then Alderman Briscoe.
Yes, my question relates to pervious surfaces used in development applications. Is there a council strategy to encourage the use of pervious, am I using the right word there? Surfaces rather than non-impervious surfaces in Hobart? Impervious surfaces versus whatever the opposite of pervious is.
Sealed? How about we go sealed? Through you, Chair. There is a preference to use sealed surfaces on traffic turning areas to minimise tracking of gravel, etc., onto the road reserve.
Well, okay. The second part is, but with regards to wanting water to infiltrate into the ground, is this not counterproductive to have non-pervious surfaces everywhere?
Through you, Chair, that is usually the treatment of the runoff of that water is usually addressed in the stormwater provisions of the code.
All right,
thank you. I might leave it there, Councillor Harvey. Alderman Briscoe.
I've got 2 questions, Chair. First one being, is there any real reason why we can't meet in person? Because I noticed that during our little short break, there were 3 people in the same room, and we are a small committee. So is there any legal reasons or safety reasons that we can't meet in person?
I'll take that on notice and refer it to governance, I think.
Okay. Thank you. I didn't realise that we made decisions in governance about COVID stuff, but anyway, the second question is, and I imagine this will get deferred to another committee anyway, but I'll ask it. when we go to the tip, we've got to show the tip in McCarvey's Gully. We've got to show our vaccination status. Yet when we go into the tip shop, we don't. Isn't this a issue that both properties are on council land? Why is it safe to go to the tip shop but not to the tip?
Mr. Fisher, can you answer that, or would you sooner be referred to governance?
Chair, I'm happy to answer the question. The tip shop's not a council workplace, therefore. Oops, sorry. Can you hear me now, Chair? Okay. Look, the tip shop is not a council workplace. It's obviously run separately to council spaces, so our policy doesn't apply there. We don't require vaccination. Oh, sorry, we don't require vaccination status at the tip anymore. That's just about to change. We've put in place processes by which people can enter the tip, and we provided protection for staff at the who work at the tip to allow people to do that. We just ask that people be masked and observe the social distancing policies, just to overcome that that problem of people, the difficulty of people who are in their car and all they really need to do is pay by card to access the tip. So there's been a change in that policy just recently.
So supplementary question through you, Chair. How will this be advertised to the public?
This isn't really a planning matter, but just if you could just make your answer brief, Mr. Fisher.
Through you, Chair, the change in provision will be made in the same way that the current advice to visitors to the tip is made, where they're required to wear their mask, and a requirement to show vaccination status will be removed.
Thank you.
Any further questions? I have a question to you, Ms. Abbey. In relation to investigations of visitor accommodation concerns or breaches by neighbours, could you provide the number of visitor accommodation approvals that are being investigated at the moment, please?
Thank you. I'll take that one on notice.
Thank you. All right, if there are no further questions, I'll ask somebody to move us into the close. Thank you, Alderman Briscoe, and I thank those people who've had the patience